Good afternoon, everyone. Thanks for coming to our second legal philosophy seminar this term. It's my pleasure to welcome our speaker today, Dr. Seth Lazar, who's joining us all the way from the Australian National University. It's a pleasure to have you here and make the long trip and spend some time with us. Seth works mainly in just war theory, political theory more generally. He's published numerous papers and been quite a prolific writer, in fact, on topics of self-defense and killing and just war in general. He's also the holder of an Australian Research Council early career fellowship grant, for which he's the primary investigator. I think the title of the project is Justifying War. He's also working on a project dealing with killing and the ethics of war and uncertainty, for which he shared some ideas this morning with one of our graduate philosophy classes. It's a pleasure to have you there as well. So today, Seth's going to present a paper called Proxy Battles in the Ethics of War, co-authored paper with Laura Valentini from LSE. But welcome, so I'll turn it over to you.
Thanks very much. So my screen here has the time in Canberra come up on the top left-hand corner, and it's 5:30 in the morning there. And I arrived a couple of days ago, but no excuses. I'm very, very excited to be here, and it's a great, very honoured to have been brought over, and it was lots of fun this morning chatting with the grad students. And so now I'm going to share some work in progress that I've been doing with Laura Valentini at LSE. Laura is a political theorist who has worked a lot on methodological debates in political theory, and as Mike said, I have worked a lot on just war theory, and this paper is really animated by the thought that there hadn't been as much interaction between those two fields as you might expect, given the sort of people who are working in both of those fields. We've all come out of the same programs, we'll spend a lot of time talking to each other about other things, but we haven't spent a lot of time talking to each other about the ethics of war. And what Laura and I figured was that there are quite a few ways in which recent thinking about the ethics of war could be informed by looking at some of the methodological work that has been done in political theory. So this is experimental in another way. This is my first ever co-authored paper, and this is my first ever PowerPoint presentation. I've done this presentation once before. I don't normally use it, but Laura does, and I feel like in the spirit of co-authorship, it was important to take that on. But it actually works quite fun. I haven't got anything funky, just what I'm going to say, more or less. So this is the sort of shape of the debate in the ethics of war. There's this kind of orthodox school that tries to vindicate something close to the norms that are given in international law. What I'm going to talk about is mostly going to be just elements of what's called the jus in bello, so the justified principles for the justified conduct of war. And the kind of standard principles that people tend to endorse, if they're in the orthodox camp, are ones like the moral equality of combatants, or what I'll sometimes call combatant equality, and non-combatant immunity. So combatant equality just states that the soldiers on either side of a conflict enjoy the same permissions and face the same prohibitions, irrespective of the justification of their cause. So regardless of whether you're a German soldier fighting for the Nazis or a British soldier fighting for the Allies, the norms that guide and constrain you in war are just the same. Most famously, that was defended by Michael Walzer, but in recent years it's been defended more by people like Henry Shue, Jeremy Waldron, Yitzhak Ben-Baji. And in recent years there's also been a revisionist school of thought emerging about the ethics of war, which has really started from first principles and tried to think through the morality of war on the basis of those first principles, governing the ethics of killing in other contexts. And what it's come up with is a very revisionist take, not only on the methodology of the ethics of war, but also on the actual substance. Basically, it's argued that the idea of combatant equality is morally disastrous. The notion that there's anything that a soldier who's fighting for an unjust cause does that can justify the killing of people along the way, whether the innocent people he kills as a side effect or the people he intentionally kills, strikes them as almost absurd. There's no symmetry in any other case where force is used. If someone attacks you and you defend yourself, the fact that you now pose a threat to that person doesn't mean that they're suddenly permitted to harm you, given that they were the person who attacked you in the first place. That, I think, is quite in line with common sense. The other part of the revisionist view is somewhat less in line with common sense. which is that non-combatant immunity too is the very best, slightly dodgy generalization. And the idea behind this is just that outside of war in ordinary circumstances, revisionists have argued that it can be permissible to use lethal force against people who don't directly pose a threat to you, but who are responsible for contributing to a threat at some stage during that threat's history. Since non-combatants often can be considered responsible, at least somewhere down the causal chain, for the threats that are posed by their state, especially in democratic states, the argument is that the principle of non-combatant immunity is actually misguided. And what we really need is a distinction between not combatants and non-combatants, but something like the responsible and the non-responsible. This is also going to mean that soldiers who are fighting for a just cause are in pretty much the same position as non-combatants, and killing them is just as seriously wrongful as it is to kill the non-combatants. So that's the sort of the broad cast of the debate. There's been this orthodox view, first invented by Michael Walzer, attacked by people like Jeff McMahon, David Rodin, Cecile Fabre and others, who have presented this revisionist alternative. And then there's been a kind of pushback in favour of the orthodox view. Now, at the same time as all this debate has been happening in just war theory, there's been a lot of work going on in political theory about the nature and purpose of political theory. And there have been some particular questions that have been cropping up. And what Laura and I think is that these kinds of ideas are going to be, can be fruitfully brought together. If we bring together the insights from the political theory debates onto the just war debates, we might find out some fun stuff. So in particular, we think that some of the controversies between the just war theorists who are revisionist and orthodox are really going to come down to deeper disagreements about these more substantive methodological issues. We call them methodological. You could also call them second order, first order. You could make the contrast between second order and first order. The key point is that these are big questions about what the purpose of political theory is, why we're doing it. And we think that you can get, for some of these debates, you can show that they're proxy battles in the sense that people think they're disagreeing about these substantive first order questions, but really their disagreement runs much deeper. We also think that there are going to be a few substantive lessons that we can bring out by looking at it in this way. So just a couple of qualifications about what we're going to do. We're just going to talk, I'm just going to talk on behalf of us both, about the jus in bello. Okay, so a lot of the same stuff I think could be said about the other aspects of the ethics of war. And we're just going to choose two particular methodological debates that have cropped up in political theory. We had a few more in the paper, but we thought these were the ones that were most interesting. And what we would really like to do through this paper is to just spark more interest in the ethics of war from political theorists who are familiar with other areas of political philosophy, and just to see whether there can be further insights gained by thinking about it in a more joined up way with the rest of the field. Okay, so yeah, I've already said that about methodological. The two questions that we're going to talk about are the one over the site of justice, the site of normative principles, and the other one is about the role of feasibility considerations in political theory. I'll say a bit more about each of them in a moment, but just to give you an overview, the site of justice debate is about what the normative reasons that political theorists talk about, what subject they apply to. Do they apply to institutions or to individuals? And what order of derivation do we then get for the reasons that apply to individuals? Do we have a way that works like you start out with the reasons that apply to individuals and you derive your institutions from those? Or do you start out by working out the reasons that govern institutions and then derive the principles that govern individuals from those? And the feasibility question is the extent to which facts about the world that make it difficult for us to do what we ought to do constrain what it is that we ought to do. Okay, so here's how the paper is going to go. So first of all, I'll talk about just war theory and the site of justice, and I'll talk about this sort of the way in the role of the site of justice debate in political theory. I'll show how we can frame the debate between orthodox and revisionists through the lens of this political theory debate, and I'll show some of the payoffs from that. I'll then talk about just war theory and feasibility constraints, and do the same thing, give you a brief overview of the debate in political theory. It will be particularly brief because that's really Laura's part of the papers, so I'm just going to say what I remember. And then going to talk about some framing, ways this helps us frame the just war theory debate, and then implications, and then I'm going to wrap up. Okay, so let's get started. So the site of justice. So what we distinguish between here is a political and a non-political approach to the question of what it is that principles of justice are supposed to govern. Okay, according to the political approach, the idea is that different principles, different fundamental principles govern different practices. And in the sort of standard Rawlsian view, the basic structure of society is one of these practices, and the principles of justice govern the basic structure of society. So you see this most clearly in Rawls' account of distributive justice, where Rawls argues that what we need to set up is a system of pure procedural justice where the social and economic incentives are organised so that they work to the best advantage of the worst off. And as long as you've done what you're supposed to do in accordance with those institutions, then you're fine. So if after having done that and paid your taxes and worked appropriately, you then want to be selfish and pursue a career where you're going to maximise returns to yourself, then that's absolutely fine. The principles of justice don't constrain your personal choices, except insofar as they come up against the institutions that those norms of justice govern. So I've kind of said that. Yeah, and then the idea is that there's this order of derivation that goes from the norms governing principles of justice down to the individuals. And there could be a separate question asked about what norms directly apply to individuals, but as far as the domain of justice goes, it's the norms of justice that govern you. So maybe you think that it's really important for people to give to charity, but as long as that isn't mandated within the basic structure, it's totally optional. Okay, and as far as the basic structure goes, only what it says governs what you ought to do. So that's the kind of Rawlsian approach. In the context of global justice, you might associate it with people like Thomas Pogge as well. And then there's a non-political alternative, and this is most commonly associated with Jerry Cohen, whose view was really that, Cohen thought that the Rawlsian idea was just completely incoherent, because if you really care about making the worst off as well off as they could be, then you shouldn't be prepared to just be selfish and go and take your high-paying job. I don't want to say in a law firm. You should be motivated instead to do something that's going to work to everybody's advantage, like teaching at university, for example. That's something, he thinks it's incoherent to hold the two views, that you might just think it's okay to be selfish in your personal life, even if you thoroughly affirm principles of justice that govern the basic structure of society. And ultimately thinks that the way to work out what norms should govern the institutions of society is to start out by thinking what norms are appropriate between individuals. So in Cohen you get a lot of cases where you think about what would be appropriate to do in interpersonal settings. So he has examples of going on a picnic and living in a shared house. The sort of things that it would be fair for you to do, ways in which it would be fair for you to treat other people as regard distributions. And then the idea is that you go from that to the rules that govern the basic structure of society. Cohen just calls them principles of social regulation. And they're really an attempt to implement and approximate the rules that are appropriate to individuals and individuals' conduct. So this is kind of the two approaches. The political approach is very much top-down. The goal of normative theorizing is identify the appropriate institutions. We then derive what individuals are supposed to do from those institutions. And the non-political approach is bottom-up. You start out with the norms that apply to individuals, and you derive the institutional norms from an attempt to implement and approximate those norms governing individuals. And what we're going to find is that the same structure is very much mirrored within the literature on the ethics of war. So on the one hand, you've got the orthodox theorists, and pretty much all of these folks are political. And there's a couple who I'm going to introduce in a moment who have a mixed view, which is one of the interesting insights of thinking about the ethics of war in this context. But most of them are political. What they're doing is they're focusing on the norms that should govern the laws of war, essentially. That's what they're trying to vindicate. As far as the norms that govern individuals go, for the most part, orthodox theorists, people like Henry Shue, Jeremy Waldron, Itzhak Ben-Baji, they don't really say a huge amount about what individuals should do. What they want to defend is the current laws of war, and they want to argue that they're justified because they minimize wrongful harm. That's the idea. So minimizing harm, standard consequentialist notion, that's fine. They want to in particular minimize wrongful harm because harm that is not wrongful isn't something that's quite so bad. Harm that is wrongful, which is what you get a lot of in war, is particularly bad. So their idea then is that the prescriptions that govern what individuals ought to do derive from these domain-specific principles. And this is how you get combatant equality and non-combatant immunity. Even if they sound counterintuitive, if you were to apply them at the interpersonal level, that's not what matters. What matters is that this is the set of laws of war that is going to minimize the wrongful harm that war involves to the greatest degree. And that's what our goal should be as normative theorists, is to work out the institutions that should govern war. Okay, so the revisionist alternative, as you can probably guess, is much more like the Jerry Cohen style approach to political theory. The notion is that these fundamental principles for interpersonal conduct extend to war, and the basic principle that they affirm is don't kill the innocent. Now, innocent needs to be qualified. What it typically means for these views is that you're not liable to be killed. But that's the idea, that what we need to do in order to work out the norms that should govern war is to think about interpersonal scenarios. And so sometimes they come in for a little bit of ridicule for this reason. You can think of examples like Jeff McMahon's implacable pursuer, who's a character who's had a device implanted in his brain and who is chasing you, being controlled by a bunch of other people from, behind a Wizard of Oz style screen. Because their approach is about working out the norms that govern individual interaction, these kinds of arguments are legitimate, whereas for the orthodox view, they'd be completely illegitimate. The whole idea of the orthodox view is that you need to think about war and the institutions that are appropriate to justifying war. And this alternative view, where you just think about what individuals ought to do, is a non-starter. And then the way in which these people think that you should get to the laws of war is really like with Cohen. You're trying to approximate, trying to implement the moral principles that govern interpersonal conduct more generally. And that is, that can come in different ways. You can think of it in a very naive, sort of direct way, as about just trying to enact in law, codify in law the moral principles. You could just have one law of war that says, don't kill the innocent, if you wanted to be really literal about it. Or you could think about it as, an attempt to approximate the morality of war. So rather than seeing interpersonal and institutional morality as being completely dissociated based on different principles, you could see them as being, one being an attempt to approximate the other. So that, I think, is the broad framework. Okay, don't we called these lessons before. This is sort of the implication section. So the first thing we think about this is that there's a sense in which this is a good example of a proxy battle in the ethics of war, because if you actually hold the site constant, and if both sides talk about the same site, I think there would be less disagreement than there is in the literature as it stands. A lot of people, I think, converge on the idea that when you're talking about the institutions, minimizing wrongful harm is a pretty good approach. But then when you're talking about interpersonal morality, people are more inclined to think that something like the revisionist approach is right. So in a way, the two views are talking past each other, and what they really need to hash out is which of these is the more important thing for political theorists to be doing. Maybe both of them are important, but then if both of them are important, then what we really need to think about is the relationship between these two levels. And in effect, what that means is a question that I'm sure you lot will be very familiar with, is what is it that we ought to do when the institutions governing our conduct tell us one thing, but the moral reasons that govern our conduct tell us another? So how do we understand those situations when there are conflicts between what I'm morally permitted to do and what I'm legally permitted to do, or when the law permits something that I'm morally prohibited from doing? That's really the sort of the meta area of disagreement that hasn't been adequately addressed in the ethics of war literature. But if we're going to kind of find a way to move forward beyond just talking past one another, this is the thing that needs to be addressed. So what I'm going to do now is just talk a little about the different options, different ways that we can approach this. And they're going to be political and non-political, but then I'm also going to mention a mixed approach that has become slightly more popular in the literature recently, and that is definitely worth thinking about. And the central guiding question for each of these is just, what ought you to do when the institutions governing war tell you to do one thing, and the morality of war tells you to do another thing? So the political approach is basically just going to say that you ought to just follow what the institutions tell you. Okay, this is an idea that really that international law has authority over the agents whom it governs, and that it exhausts the obligations of soldiers who find themselves fighting in war. Now, there's a few challenges for this view. One of the biggest ones is that it's going to need an account of the authority of international law. And as I'm sure you all know, even providing an account of the authority of domestic law is not very easy. Certainly it's something that I would say probably the consensus among political philosophers, at least at the moment, is that it's impossible to do. And a lot of the things that you might think make it even conceivable that we could have an account of the authority of law at the domestic level are facts that just don't hold at the international level. So maybe you might think that, the fact that a law is issued by a democratic state or by a justified state or a legitimate state, that might give you reason to obey it, even if it conflicts with the moral reasons that apply to you. But obviously international society isn't much like sort of the ideal of a liberal state. International law is much more inchoate, much more fragmented. There aren't the same kind of bodies that would justify it. The sort of Razian service approach to authority also looks like a bit of a problematic one to apply to international law, because the whole idea of the service approach is that the law is justified, the law has authority, when by following it you do better by the light of your independent moral reasons than you would if you disobey it. But if international law is just radically divergent from the interpersonal morality of war, then it's not going to be, following it is not going to be a good way to do what you ought to do. For soldiers who are fighting for unjust wars, unjust causes, who ought not to be killing at all, following international law, which allows them to kill enemy soldiers, isn't going to be a good way of doing what they ought to do. What they ought to do is stop fighting. And one of the reasons why this is going to be such a big challenge for this account is that when we're talking about soldiers fighting on the unjust side, obeying the law, what they're doing is they're killing people, intentionally killing enemy combatants, at best unintentionally killing enemy non-combatants. So they're violating these people's most fundamental rights. The kinds of rights violations that ordinarily you would think impossible to justify. It's very hard to see how the fact that doing that is justified by international law or permitted by international law could possibly override what are probably our most profound obligations that we owe to one another. One way that I think some of these worries could be addressed by the political approach is if we were to think in terms of how international law could be reformed, which isn't something that people tend to like to do. And there's something understandable about that, which is that the limited constraint that international law currently provides might well be put at risk if you try and perfect it, make it too much better. Maybe this is the best we can do. But one thing that I think could feasibly be removed is the idea that combatants on either side of a war are given an explicit privilege to kill one another. So I think it's in Article 57 of the Geneva Conventions, among other places, where combatant status gives you a right to kill and right to use lethal force against enemy soldiers. I don't see any reason why international law should contain that privilege. I think that there are other ways to get the kind of things that it wants. So the sort of things that you probably want is some sense that some people should get prisoner of war status. Now I think you could have that without granting some people explicit right to kill. And if you remove the explicit right to kill, then international law doesn't condone what unjust soldiers do. And you can still say that international law, properly understood, directs unjust combatants not to kill. But if they decide nonetheless to go ahead and kill, then they ought to follow the law set out in the rules set out in the Geneva Conventions, for example. So they ought to obey discrimination, proportionality, precautions in attack. And that then removes the most problematic part of international law, which is the license that it grants unjust combatants to kill innocent people on the other side. So I think that's one way that you could mitigate the implausible implications of the political approach. So next up, the non-political approach. Again, so here the idea is that the goal of the laws of war should be to implement our interpersonal moral reasons. And the really rigorous version just says, just do what, have the law say, what you ought to do. So don't kill innocent people. Now, a lot of people think that that would be just too revisionist. It would lead to laws of war that everybody would disobey, everybody would disregard, and any constraining role that the laws have would be lost. Okay, so that's probably a non-starter. Nobody would ever agree to it anyway. But there can be slightly less rigorous versions. My own view about this is actually that you can defend something like the orthodoxy in international law on interpersonal moral grounds. So what I think is that, okay, so the moral equality of combatants is false, but there are a lot of ways in which soldiers who fight for an unjust cause in war aren't as bad as a culpable attacker in the interpersonal context. So often they're excused, often they're acting out of reasonable partiality in the context of radical uncertainty. Often they're protecting people they care about, and they don't have any choice over whether the war is going to be fought or not, they just have a choice over whether they help it to be won. I think all these sorts of reasons and others suggest that these guys just aren't the same as culpable attackers in ordinary contexts, or at least lots of them aren't. And then just combatants, I think, aren't as great as just defenders in interpersonal contexts. So a lot of the time they're just acting on the basis of orders. They're not researching and checking whether their war is just. Usually for most soldiers in war, if they happen to be on the just side, from their perspective that's a matter of luck. So they're already being kind of reckless. They're already posing threats. They've already exposed themselves to risk. And what's more, they've chosen to draw fire away from civilian counterparts. So I think with these points in mind, there's a way in which moral equality of combatants is a reasonable attempt to approximate the moral truth. Non-combatant immunity as well. I think there's a number of good arguments for why killing civilians is worse than killing soldiers in war, that don't depend on their being on the just or unjust side of the conflict. And so I think non-combatant immunity tracks those kinds of reasons. And so this is my way of addressing the challenges for this approach. I think if you endorse this rigorous revisionist account of the morality of war, then you're going to get crazy laws of war that no one can accept. But then the challenge is to come up with an account of the interpersonal morality of war that is going to give us a plausible account of the laws of war. That's generally what I take my approach to the ethics of war to be. There's another guy you've had up here recently, I think, Adel Hack, who is in the same kind of ballpark. And actually I think you've had Massimo Renzo here as well. He's sort of in a similar approach. Although Massimo is actually a pretty good example of the mixed approach. And actually I think there's a few people who favour this. And thinking about the ethics of war, this is one of the ways in which you can get some nice feedback to those methodological questions from thinking about the ethics of war. Because I don't think there's a lot of political theorists who take up this position, but it's one that's quite popular within the ethics of war literature. And this is just that there are individual interpersonal moral duties, like don't kill the innocent, but there are also institutional principles, like minimize wrongful harm. And these two sets of principles somehow coexist. And you have versions of this on either side of the debate between orthodox and revisionist just war theorists. So Jeremy Waldron takes the view that what justifies non-combatant immunity is really our interpersonal moral reasons. So it's the fact that non-combatants aren't liable to be killed, the fact that they're innocent. That's why it's so serious, why he calls it a deadly serious convention, the protection of civilians in war, and why killing them is so problematic. But he thinks that as far as combatant equality goes and the permission to kill enemy combatants, that is justified by the legal principle that more or less if you don't grant them some license to kill in the pursuit of their aims, then they'll go nuts and they'll kill everybody. So this is the only way to restrain and take hold of war and render it at least somewhat bearable. So you've got this twin justification, really. Combatant equality gets justified by appeal to institutional reasons. Non-combatant immunity is justified by appeal to interpersonal reasons. Jeff McMahon, obviously, is a member of the revisionist camp. When he's talked about the laws of war, he actually comes up saying non-combatant immunity and combatant equality both are justified in these kind of instrumental grounds because they minimize wrongful harm. At the same time, he thinks that we have all these interpersonal reasons. And obviously, you can see where the challenge for this view is going to be. It doesn't provide an answer to the question of how these reasons, what we should do when these reasons conflict. And is in even more serious of a predicament than the other two approaches, because where they could just say, look, this is part of the theory that the institutional reasons predominate or the interpersonal reasons predominate. This account has to, if it's not going to collapse into one of those two, has to be able to say why in some situations the interpersonal reasons win out, in other situations the institutional reasons win out. And that's going to be a very difficult line to walk. Okay, so next up I'm going to talk about feasibility constraints. Okay, there's an obvious connection between this methodological debate in political theory and the previous one, which I'll come to in a moment. But the general idea of a feasibility constraint is very closely tied to the moral principle that ought implies can. The idea is that there are facts about the world that make it the case that our fulfillment of some putative duty is either impossible or less likely than it would otherwise be. And sometimes we think that these facts should be taken as parameters, things that determine the scope of our obligations. That's the ought implies can idea, that if it's not the case that you can do it, then it can't be the case that you ought to do it. But then obviously there's a huge question when we're thinking about feasibility constraints as to which obstacles should count. Which ones should we take as parametric? Now there are two different approaches that you can distinguish between, depending on, if you like, how concessive they are to the exigencies of reality. The first approach I'm calling maximally concessive. On this approach you say, look, anything that makes it the case that you're fulfilling some putative norm of justice is unlikely can constrain what it is that you ought to do. Right? It can block an obligation that you would otherwise have. So, suppose that there were a normative principle that we were proposing that everyone should give 70% of their income to worthy causes. Okay. Now, I don't know about you, but it's pretty unlikely that I would ever fulfill a demand like that. It's probably true for a lot of people. And the idea of this account would be that that very fact that it's just so unlikely that we would comply with a principle that is so demanding itself prevents it from being an eligible principle. Okay, so you get a lot of this discussion in the political theory debate between people who think about ideal theory and people who think about non-ideal theory especially. That's where feasibility constraints come up the most. And obviously global justice is a central area of that debate. And then the contrast between those maximally concessive folks and the minimally concessive side, who argue that feasibility constraints, the only feasibility constraints, are the physical and psychological facts that make compliance with a putative norm of justice impossible. So this is much stricter. It's only if it's actually impossible that you could adhere to a kind of principle that principle would get ruled out as being one of justice. So if you think about the idea of implementing some sort of maximalist principle of distributive justice in the context of radical resource scarcity. In fact, in the context of rules, one of the feasibility constraints that he takes as parametric is just the idea that there should be moderate scarcity. If there were more than moderate scarcity, if there were severe scarcity, then rules would say that his principles of distributive justice don't apply. As far as psychological facts that make compliance impossible, you might think about pathologies. Pathologies of mental illness that might make it impossible for you to comply with some particular injunction might make it the case that that injunction doesn't apply to you. Okay, so again we're going to see a nice parallel between this and the jus in bello literature. And again we're going to see the orthodox theorists falling on one side and the revisionists falling on the other. So again the orthodox folks say that the laws of war should make prescriptions that soldiers are likely to honour, given the exigencies of combat. And by this I mean the stress and the trauma and the uncertainty that they inevitably and invariably face. And also these prescriptions should be ones that states are likely to uphold and abide by. So there's no point being Jeff McMahon and proposing these sort of wonderful revisions to the laws of war if nobody would ever endorse them. So you might think that McMahon's account of proposal for a kind of a jus ad bellum court at the international level that would rule on the justice of wars as they're taking place. That might be viewed as a kind of over-idealistic, infeasible prescription that can't really have normative force because it's so unlikely. And this approach takes as its standard what you might think of as the ordinary soldier when thinking about psychological stress, trauma and uncertainty. You know, it's not focusing on models of temperance, skill and courage. And obviously this leads to a defence of combatant equality and non-combatant immunity. And the idea is roughly that if you tried to get rid of combatant equality, if you tried to make unjust combatants, if you just said to them, look, throw down your weapons, you're not supposed to fight, rather than telling them that it's permitted for them to fight just combatants, that they'll just ignore the laws of war, carry on killing anyway, but do so in a way that is less restrained and less constrained. Similarly, if you tell just combatants that it's permissible for them to kill enemy non-combatants, then even if there are circumstances in which they might be justified in doing so, on the whole they're just going to take advantage of that prescription, that permission far too much, and it's going to have disastrous implications for the ethics of war. Now, the contrast with the revisionist just war theorists is very stark here. They want to talk about prescriptions that it's possible that soldiers can honour. And they don't want to think about the ordinary soldier. You know, they want to think about soldiers who show what it is psychologically possible for soldiers to do. So you often get examples being brought up of heroes who stood up against atrocities. For example, the 3 Marines who fought against the other Marines who were carrying out the My Lai massacres. Okay, and there are lots of examples like this throughout the history of armed conflict. It's not difficult to find them. The difference between this and the orthodox approach is that the revisionist approach says, well, look, if it's possible for some people to do it, then it's not psychologically impossible. So that level of restraint is something that we can expect of everybody. And this might raise some worries about, you know, how it can be possible to abide by such exacting norms. But the revisionists always have a get out of jail card with this. So if someone complains to them that the norm kill only the innocent is impossible to abide by, for example, because, you know, there are going to be some enemy soldiers who are innocent and some who are not, and it's impossible to tell the difference between them, and you can't fight without killing some of them, then they can respond that the way you can abide by that norm is just not kill anybody. Okay, so they're not rejecting ought implies can, they're just saying that in those circumstances it's impermissible to kill. Okay, so what implications can we draw from this? Well, so when we started this out, we thought that maybe the substantive debate could be traced back to a disagreement about the role of feasibility constraints. And it kind of can, but in another way, what's really happening here is that we've got 2 different groups of theorists who are applying feasibility constraints at different levels. And we think there's something quite right about this. We think that at the institutional level, it is appropriate to think of feasibility constraints in terms of probabilities. Because what you're trying to achieve with institutions is to constrain armed conflict, and you can't control the behaviour of the people who you're trying to constrain. And with that in mind, you just need to set up the laws that are going to have the best effects that you can get. But as far as the interpersonal context goes, well, the idea is that we are able to control what we individually do. So, you know, if you think about it like this, I'm proposing a law of armed conflict, and I'm thinking, look, nobody's going to obey the rule that says you ought not fight if you're on the unjust side. So it would be absurd for me to have this law to support that law. But then think about it in the interpersonal context. Think about saying it about yourself. Well, I'm definitely not going to obey a principle that tells me not to fight unjust wars. So it would be absurd for that norm to apply to me. Right? The second kind of reasoning sounds obviously wrong, while the first kind of reasoning makes sense. When you're talking about yourself, you can't use your own predictable voluntary wrongdoing as a reason to say that some norm doesn't apply to you. But when you're designing laws that are supposed to govern international armed conflict, then the predictable wrongdoing of others, I think you can bring into the picture. So, with that general point in mind, I think that there are still some lessons that we can draw for both sides of the debate from thinking about these feasibility constraints. And I think the main one for the orthodox theorists is that they've been too conservative in thinking about what can be done as far as international law goes. And it's important to remember in this regard how far international law has come since the middle of the 20th century. There have been significant advances since that period. There's some good research showing that at least among advanced liberal democracies, the degree to which we intentionally attack non-combatants has radically dropped over the course of the 20th century. And there is a very strongly promulgated norm about this now. I mean, whatever you think about ulterior motives, the reason why there was public support for intervention in Libya and the current intervention with the Islamic State is out of concern for the protection of civilians. Okay, this is not something that would have been quite so common in the mid-20th century, when all sides thought it was permissible to target civilians on the other side. So reforms are possible, and we shouldn't just take international law as given. We should think about how we can improve it. And I think that while the jus ad bellum court that Jeff McMahon described is probably a utopian proposal, the idea of belligerents abiding by its authority in the context of a conflict, just very unlikely to happen. But we can use international organisations to provide more public information about the proximate causes of war, to provide observers. I mean, we can even use social media and technology. That's already happening now in these conflicts. We're already seeing things come up on Twitter, people posting videos of what's happening. And we can use all of these resources to give a better record of the early stages of conflict. A little bit like what happened in South Ossetia, although that didn't end very well for the observers who were sent there. So I think we could do more to make public the circumstances at the start of conflict. We could do more within states to make provision for selective conscientious refusal. Okay, this is something that my adopted country kind of leads the world in. In the Australian armed forces, if you disagree with a particular conflict, you can refuse to fight. Now, it's never actually been taken advantage of, that principle. Nobody has used it to refuse to go and fight, despite Australia being involved in the Vietnam War, Second Iraq War, plenty of opportunities to refuse to go and fight. But still, it's there, and it's something that people could be encouraged to make better use of, and it's something that other states could use as well. So if you have more conscientious refusal, then you give soldiers more of an opportunity to refuse to fight in unjust wars, and that's going to make their leaders somewhat more circumspect about whether to fight them. And then there's the other point I made earlier about the combatant's privilege to kill, which I think we should explore options for removing that from international law, because I think what it does is it licenses a moral abomination, and it's probably better if international law doesn't do that. The last point is just the use of new technologies. Obviously, drones are very controversial. They have lots of raise lots of instrumental worries. But it seems that if you do hold other things equal, the capacity to be more discriminating in the use of force is something that should be welcomed and should be used to a greater degree. Okay, so the lessons for the revisionist theorists, I think, from here, is that they're obviously insufficiently attentive to real-world constraints in war. And I'm just going to draw attention to a couple of them. The first is the uncertainty that soldiers invariably face. Not just soldiers, political leaders as well. All of these conflicts are shrouded in uncertainty. All of the most important facts are not known for sure. This is the cliche about war, the fog of war, that everyone's familiar with. And yet, the best theories that we have of the ethics of war don't really say anything about what one ought to do, given that one is uncertain about the non-moral facts. All they tell us about is objective permissibility, what you ought to do if the facts are thus and so. And I think this is obviously inadequate, and what we really need is to think about how we should build uncertainty into our account of the morality of war. And there are just a couple of options that I want to lay out for you. The first way you can do it is to identify the objective moral reasons, you develop your theory of objective permissibility, and then basically you apply it using some kind of decision rule that allows you to apply it in uncertainty. So, the most familiar way to do this would be to use your theory of objective permissibility to set out a way of ranking the possible outcomes that might come about from your action, and then use that in a decision theoretic calculation of what you ought to do. The next approach is to come up with an account of first order moral reasons that govern what we may permissibly do given our uncertainty. So rather than just take the objective approach and try to apply it, you plug uncertainty straight into your moral theory. One of those approaches is going to be the right one. I think it's the first. But this is something that revisionist just war theorists haven't yet done and that is urgently needing to be done. The next point about their inadequate attention to real-world constraints has to do with the way in which stress and duress might be sufficiently psychologically debilitating that they can make actions impossible for an agent. And this is just something that hasn't been talked about, but seems so obvious in the context of war. We were talking about it earlier in the graduate seminar. And here I think that part of the problem is that everything's kind of viewed through this kind of binary polarization. Either you're trying to defend combatant equality or you're not. So the only way in which stress and duress could be relevant would be if it were to give a permission to soldiers to fight unjust wars, and that seems far too much. But I think it would be a good idea to stop thinking in those binary terms and to actually just look at it from first principles and think, okay, well, so suppose that if you do nothing, you're going to die, but you really don't know whether using lethal force is permissible. I can kind of agree that killing somebody just to save your life, even though it's objectively impermissible to kill that person, is definitely not on, right? Sometimes morality is that demanding. You do have to lay down your life rather than kill an innocent person. But what about taking an additional risk of killing an innocent person? You know, rather than dropping your weapon, spraying suppressive fire towards an area, might kill somebody. You're not trying to kill anybody, but it might kill somebody. Could that sort of thing be permissible in virtue of the fact that it's just not possible, it's not reasonable to expect you to drop your weapon and just do nothing? I think that's the way to look in terms of developing how we take stress and duress into account within our moral theories. I don't think it's going to give anything like combatant equality as a result, but I think it will give a more nuanced and a more realistic approach to the morality of war. Okay, so just to wrap up, a lot of the discussion between revisionist and orthodox just war theorists has been traceable to these deeper disagreements between them. Disagreements over what site normative principles are supposed to apply to, and in particular, disagreements about how feasibility constrains what you ought to do in the context of war. Now, we think that showing these disagreements should make clear where the decision points are for the contemporary debate. We need to give an account of what the relationship is between the institutional norms and the interpersonal norms that govern one's conduct. You know, I think I've got an account. I think, you know, the interpersonal norms dominate the institutional ones, and I think that's the kind of the intuitive starting point. Anyone who wants to argue that the institutional norms dominate the interpersonal ones, I think, has a fairly heavy burden of justification to meet. And we need to think about as well about the role of feasibility constraints in determining what it is that one ought to do in the context of war. And I think that both the orthodox and the revisionists have questions to answer here. The orthodox theorists have been too conservative. The revisionists have just not been sufficiently attentive to the ways in which these real-world circumstances interrupt the application of their approaches to the ethics of war. So, with that, I'll turn it over to you and look forward to your questions. Okay. Is it right if I sit down for this bit?
Yes. I can take some questions.
This is going to look quite funny just sitting behind me while I'm just sitting here on the screen with "thank you." This looks a little desperate. Okay.
Else? Yes, sir.
Thanks very much for that. That was great. So I'm interested in taking the proxy battle and moving it back to the original, to its location. So I was trying to think, when I was reading this last night, what a mixed approach would look like not in war. And I wondered whether it would be harder to sort of find a mixed approach in the argument between Rawls and Cohen, or at least it would have to look different. And I wonder if this was because I was trying to, my instinct, this is sort of my intuitive line of thinking was, well, we give personal morality, a kind of the demands of interpersonal morality almost take on a certain urgency in war that they don't the rest of the time, because the stakes are so high, because it's about killing, and because often you don't have sort of feasibility constraints, you don't have time to have dialogue between the personal and the institutional in a way that we might over time in normal circumstances. And actually I was interested to hear you mention conscientious refusal, because I thought we don't have analogues to conscientious objection and refusal in quite the same way in a lot of our sort of daily interactions with institutions and so on. So I was just interested, part of the appeal of what you're saying is if we recognize that what's really happening is a dispute over the site of justice, similar to that of sort of the political and non-political approach to principles more generally, have you given any thought to what a mixed approach would look like when applied to the sort of thing Rawls and Cohen are talking about?
It's quite hard to think of how it would come out. I mean, I think the reason why... so here's the reason why the political approach is quite appealing in the context of distributive justice, which doesn't apply in the context of war. If you think about your distributive obligations, your obligation to help other people, it seems quite sensible that we should develop a system of taxation that makes it the case that you discharge all of those obligations in one go. That certainly seems like the right ideal to aim at. And you can really see the political principles as a way of discharging any obligations that you might have, so that over and above that you don't have to do anything. And there's just no real analogue to that in the context of war. There's no way that the laws of war can be construed as enabling you to discharge your obligations in the same way. So I think that's why there's a big disconnect between them, and in a way why there's less need for the mixed approach in the context of distributive justice, because the clashes that it describes, you'd have to be somebody who thinks that you have these norms that govern how much of your income you ought to give to other people, and then there's the norms that govern taxation, and that when they conflict, there's an open question as to which of them triumphs. Now, a lot of people are just going to think, well, no, you pay your taxes, and then maybe you do some other stuff on top of that. I wrote a paper a while ago on associative duties and their interaction with general duties. And I actually presented a case that could be an example of a mixed approach there, where I imagine somebody who has a tax bill that they have to pay, but at the same time needs to use that money to help their son out of some terrible scrape. So it has the conflict between the associative duty to aid their kid and the general duty to fulfill their obligations under the tax system. Now, I actually think that in that context, I can see the associative duty winning out, and I can see it being a genuine conflict. So that's the sort of situation you'd have to come up with, I think, to think about mixed approaches in the context of distributive justice.
Okay, good. Can I have a quick follow-up? Just to push that a little bit further, I find that the sort of difficulty, the implausibility of a mixed approach, in a way makes me suspicious of the mixed approach in the war case. At least it makes me wonder whether it ultimately collapses into the non-political approach. And I kind of wondered whether that's your revisionist non-political approach. I can't really see sustaining a mixed approach that doesn't collapse into that. Because it seems to me, it's not just that, so the mixed approach, you sort of say does this collapse into the other two, what to do when the reasons conflict? I can't see a case where you could have a sort of conflict that wouldn't collapse, not just that would. Conflict would have to necessarily, given the intuitions that are motivating the mixed approach. I can't imagine a conflict resolving into anything but interpersonal morality winning, or else you weren't really doing mixed, you were doing institutional to begin with. Given again the stakes of interpersonal morality in war.
I agree that is the problem for that view. I think if you look at stuff like Jeremy Waldron, like what Jeremy Waldron writes, he says that as far as killing civilians go, interpersonal morality triumphs. But then he thinks that for killing soldiers, the laws of war come into play, and they make it permissible to kill even soldiers on the just side. Now, he doesn't have an argument for why it is that that it suddenly becomes permissible to kill these people who are otherwise innocent, and that's a problem. But that's the kind of view that they would have to hold. Jeff McMahon has this very brief discussion in one of his papers on the morality and law of war, where he talks about what you ought to do when a moral prohibition conflicts with a legal permission, or legal permission, and then so for permissions, prohibitions, and requirements of legal or moral stripes, what you ought to do when they conflict. And he gives this really short, kind of broad summary. I think it's something like obey the prohibitions, but there's nothing really behind it. It's not like it's just a sort of an intuitive, well, probably this is what you should do. And again, I think if you're going to have any case in which the legal norms trump the interpersonal ones, then you're going to need that account of the authority of international law. Yeah. And I think it's reasonable to say that if you've got that account, then why would it trump in some cases but not in others? Yeah. The stakes could make the difference, but I think it is a very difficult line to tread.
Thank you. Thanks.
Questions? I guess I had a question about the authority. We were sort of chatting about this earlier, about the authority of international law. But I can see why that's going to be a crucial issue to try and work out. What kind of account could we provide to justify the authority of international law? And I think it's a crucial issue because, in one sense, because both the orthodox and the revisionists have to answer it. Right? If you're an orthodox, you've got to come up with an account which would justify treating international laws of war, jus in bello, as authoritative. And if you're the revisionist, then you've got the same task. So in that case, it's not so much a proxy battle, but a genuine, substantive battle all the way down. On the other hand, though, I wonder whether I can see both of them being pushed that way, but I think there are also reasons why you might not want to suppose that that's going to turn out to be a crucial issue. If you are suspicious about there being any political obligation to obey the law in the first place, then whether you're the revisionist or the orthodox proponent, you may want to claim that the real locus, I don't want to mix and match the words, but the real site of the authority of international law is not on the laws themselves, but rather on particular decisions or acts. Right, so I'm sort of thinking about fragmentation of authority. It's a view that I think John Tassiolis develops a little bit, or he's defended this view, that when you're thinking about justifying the authority of law, it's a mistake to suppose that your task is to justify the general authority of the law rather than fragmented rules, decisions, policies here and there. So I'm just wondering whether that's going to split the orthodox and the revisionists apart in some way. Whether that's, I'm just sort of thinking, if somebody said, before you can figure out which of these accounts of the laws of war is to adopt, the orthodox or the revisionist, in order to do that, you've got to come up with some sort of account of the authority of international law. I don't want to say, hold on, that's a task which I think there's good reason not to discharge, even though both of them are heading that way. So I'm not sure whether that shows that those views are wrong-headed in that respect, or it's going to further divide them. I'm not sure.
No, I think, I think I should just revise that claim. So the authority of international law generally isn't what's needed. It's the authority of the laws of armed conflict that has to be the case. So in that sense, it could be the case that those laws are authoritative, even if international law more generally were not. And there's no reason why they should be sort of tied to one rather than the other. I think the real challenge for developing that account is that the stakes are just so high. And there's just a weird inconsistency, especially, and this is one that really applies to the mixed view. I don't think I talked about. It's very strange to have an account of the morality of war for which when you're talking about institutions, you're a consequentialist. But when you're talking about interpersonal moral reasons, you're not a consequentialist, you're a deontologist, you focus on rights. And that's basically what quite a few of these people do. It's something explicitly that Jeff McMahon does. The goal of the laws of war is to minimize wrongful harm, but interpersonal morality definitely doesn't have that goal. And in that circumstance, it's very hard to see how you could get any kind of account of the law of armed conflict trumping our interpersonal moral reasons, except by endorsing at the interpersonal level a kind of consequentialism that goes along with the laws of armed conflict. And conversely, if you want to endorse the revisionist view of interpersonal morality, it's very hard to see how you can justify laws of war that are built on consequentialist grounds. So there's a fundamental dissonance between them, between the two different levels, that make the challenge particularly hard. But I think you're right, even in domestic society, certainly my take on the political obligation debate is that philosophical anarchism is the most plausible position, at least if you're trying to justify a general obligation to obey the law, rather than an obligation that some people hold to obey some laws. And this doesn't look like, well, the laws of armed conflict don't look like they're going to be an easier case than domestic law, which often, we're talking about traffic law and stuff, that stakes are pretty low.
Yeah, the microphones are just to record the sound for the video rather than projecting the sound.
Okay. Okay, so it seems clear that part of your project is to find some kind of middle way between like a realist position and like a pacifist position. But it's unclear to me whether you can actually convince the pacifist that they need to abandon their theories. So like when you talk about the challenges to their revisionist theories, you talk about part of the challenge they're going to face is that it's not enough for them to say, like, when you get put in X situation, a very real option is to just not kill. And you want to give them some kind of guidance in a real world scenario, but like it's unclear to me why would a revisionist abandon their position in the first place? Like what compelling reason do you really give them to say that that's not enough?
So one thing that and I wasn't very clear about this in the talk, so thank you for bringing it up. So one thing that I try to do when I write about this is I try to make it very clear that I take pacifism to be a very serious option. It's just not very interesting, right? So I think that it's very easy to get to a pacifist account of the ethics of war very fast. It takes a couple of steps. People have rights. War involves violating rights. It doesn't achieve anything good enough to justify violating those rights, so we should never fight wars. But then there wouldn't be much point thinking about this stuff. I think the interesting questions in the ethics of war are really about whether you can carve that middle path between realism and pacifism. And if you want to get off the boat before even getting there, then I don't think there's anything utterly compelling that one can say against the pacifist. I mean, you can give the usual examples, wouldn't you have fought against Hitler and all that sort of thing. But, I think it would be quite reasonable to say something like a lot of people say with torture. You can think of cases in which torture would be justified, but if you institutionalize a principle that licenses torture, then you get horrendous implications. So we ought to have absolute prohibitions on torture. I think you could just as well say the same thing about war, that, we can come up with cases in which war would be justified, but if you institutionalize war making, then you get all the terrible implications that follow from that and all the unjust wars that follow. And I don't really take my project to be showing that view is false. In general, I'm against killing. So that's the... If other people are more against killing than I am, then I'm not going to desperately try and persuade them that they should be killing more people. So I take the real challenge to be to try to persuade people who have already decided that killing can be justified, that they need to do it in a way that is constrained as far as possible, And so my main focus for that is on protecting civilians in war. But you know, all of this stuff comes out of the same sort of broad animus.
It just seems to me that some of your concerns that you brought up in the presentations were, say, taking away the limits on non-combatants, like, and making them up for the fair game. It seems to me that if we concede the ground that, like, we can conceivably talk about a just war, we open ourselves up to the same kind of like abuse of it. Like, so if we concede the ground that there can be a just war rather than take like the pacifist position that no war is just, we've in a sense already conceded too much and already opened ourselves up to like gross abuses of the system. So it seems to me like a much more pragmatic way to go about it is to just not concede that ground at all and condemn war in general and killing in general, because it gives us a much harder stance and we're not susceptible to that kind of
Yeah, I mean, I think that if you don't say anything beyond don't fight, then I think you're in an even worse position than the revisionist is, because then you're saying that anybody who does go ahead and fight, all the killing that they do is equally wrong, so they should just, there's no real reason for them to choose different means or different methods. I suppose what they should probably just do is get it over with as quickly as possible, and doing that is going to lead to a lot of atrocities along the way. So it's important for me that I do genuinely think that some types of killing are more seriously wrongful than others. I think that it's more seriously wrongful to kill civilians than it is to kill soldiers, even if the soldiers are morally innocent. And that is something that, you know, to a certain extent, even a pacifist should be able to endorse the things that I say on that point. And then we can disagree about whether fighting is justified under certain circumstances. But again, it's just not it's not a debate that I choose to give a huge amount of attention to, just because I think that it's a good idea to use moral and political philosophy where possible to advance causes that you care about. And I care about limiting killing in war rather than justifying killing in war. But I think that the arguments would be there if I was to dig into it to argue against pacifism. I just don't really want to.
So I have a specific question just relating to one of your suggestions to the revisionists surrounding what to do in situations when, say, a soldier is in fear for their lives. Your suggestion is, you know, potentially they could spray suppressive fire against people who are shooting at them, hopefully distract them long enough that they can escape. And what that's doing is essentially saying, could it not be morally acceptable to impose a certain amount of risk on other combatants in order to potentially save your own life? And that to me seems to imply that there's a kind of calculus that comes into play there about, you know, how much risk is acceptable and how do I calculate the kind of risk that's happening in that moment. And because this is specifically about decision-making processes in war, I'm wondering if you have any answers or suggestions as to how that might happen, or kind of what kind of calculus you might be able to apply in a situation where you are kind of afraid for your life.
Yeah, so I think it's going to be different from the sort of things we were talking about earlier today, which is where we were talking about a standard for subjective permissibility that might be developed using decision theory together with an account of deontological ethics. I think this is going to be a much more rough and ready idea. What I'm really trying to draw out is just the notion that things have been, the debate has been presented in a kind of all or nothing way, where if you think that stress is requirement blocking, you know, trauma and stress can block requirements that you have, then you have to be saying that that means that it's permissible to kill somebody just in order to save your own life. And that seems counterintuitive and far too extreme. So what I want to draw on is that, you know, those aren't the only options. You know? I mean, if you think, it's hard to think up cases outside of the war context because you don't typically face this sort of circumstance outside of the war context. But I think that, yeah, that's the idea. It's just that it could be permissible to expose them to some degree of risk, to fire blindly in the broad direction, or it might not be required that you not do that. And in general, I think that you don't want your moral theory to be too rigorous, and you need to, if you take the idea of ought implies can seriously, then you need to think about psychological possibility. And it does seem quite plausible that just taking the heroes as the model of what is psychologically possible doesn't really capture what the ought implies can principle is about. Because yeah, it might be psychologically possible for them, and good for them. It's nice that there are people like that. But would it be psychologically possible for me or for you, the ordinary person, assuming you're not a hero? That's something that is a little, that's a little harder to discern. And in those cases, I think, if you genuinely think that ought implies can, then we just need to think a little bit more about these kind of things. Another thing that Lara and I were talking about that we didn't put in the paper was this idea that derives from the ideal, non-ideal theory debate in political theory, and the sort of the notion of the sucker exemption, which is basically, why should I be the one sucker who does what they're supposed to do when everybody else is not doing what they should do? Right? And this is another way in which non-compliance might give rise to permissions. If everybody around me is killing one another impermissibly, if nobody is paying any regard to what they ought to do, why should I be the one person who valiantly lays down his life in order not to dirty my own hands? And there I think there's quite a strong intuition that pulls that says, look, if everyone's acting wrongly already, then it's no worse for me to be the one who does it than for someone else. If I've got to choose between wrongly killing someone and being wrongly killed by someone, then it seems like I should be at least permitted in a kind of second best sense to do that. And that's something that you just won't find in contemporary work on the ethics of war, because there is just no license granted or even attention paid to the psychological trauma in which these decisions are made.
So I'm interested in this idea of the taking a different, having different choices to make when you're under stress in a situation like that. And I was thinking in the context of police and killing and shooting, and that my understanding is that police are trained that they shoot to kill, and that is the training that goes into it. It's not maybe shoot to wound or shoot to, deflect, to scare the person. So I really think it's very useful to be applying these kinds of ideas to situations of violence and where there's risk of death like that. I'm also very interested in your discussion about selective conscientious objection and so on, because we've certainly seen that with the Iraq War in Canada and their cases now at the United Nations level, where basically people who were voluntary combatants and who decided that they could no longer be involved in that war, and for very strong moral reasons, personal reasons, they made those decisions, and of course they're going to be punished to the much greater extent than other people who just leave the war. So I think it's really important that we're discussing these things, and I think it's interesting that I would like to see more connection between the humanitarian law, international humanitarian law, and how we recognize people and give them protection from persecution from, for example, leaving an unjust war. Then I'd like to see more of that. I don't know if that's been developed at all in your thinking.
Yeah, so the way I've always thought about selective conscientious refusal is that it would be a provision within the military statutes of states, like it is with the Australian Army, Armed Forces. But I mean, it would be a good cause for the ICRC, for example, to take up, to try and promote, to make it into a norm of international law that at the very least, punishment for selective conscientious refusal is kept within certain bounds, because at the moment it is pretty exacting. Now, the obvious worry that will come back from members of the military is that there would be too much malingering, basically. People would be taking advantage of these provisions to get out of fighting wars that they would otherwise fight. Now, that's an empirical claim, and it's very hard to know whether or not it's true, and I'm in a much worse position to assess it than probably the people who make it are. I think that there are reasons to think that these options will still be taken advantage of pretty infrequently. I mean, just given the Australian case, like I said, it's never been taken advantage of. Largely because the kind of bonds that bind soldiers together mean that when they go to fight, for the most part, they're not thinking about the cause they're fighting for, they're thinking about protecting their friends and being there with them, and they wouldn't want to let them down. And that's something that's unlikely to change. But it could definitely have a symbolic significance if it changed to some degree. I mean, I think certainly in Israel, the people who have conscientiously refused there to fight in the various conflicts in Gaza, I think they've made a huge impression internationally and have served an important role. And so I think that it might end up being more symbolic than substantial. I don't think you're ever going to get a situation where a state is unable to go and fight a war because of the number of people who have refused to fight. But if you think of the attention that every single refuser gets in the media, I think that it could play an important kind of chilling role. And if that was something that were discussed at the international level, then I think that could be very promising. Just to pick up on that for a moment. I mean, I see the case with Israel at least.
Sorry, Garrett.
Sorry.
Microphone.
Oh, yeah. So just to pick up on that for a moment, I see the case of Israel where there's a draft system as perhaps giving the justification for the conscientious objection. But in the case of a volunteered army, my concern would be that, in part, you're shifting the loyalty of the army, of the members of the army, away from the democratic process and saying, well, at least in a democratic sense, right, away from that process and saying, well, generally speaking, the army is at the disposal of the democratically elected leaders, and here you're saying then that at least in some cases the soldier who's volunteered can then conscientiously object, and I have concerns with that in part because what you're doing then is just shifting that decision-making process away from those who've decided to go to war, and legitimately so, at least in certain circumstances, and you're undermining sort of that conditions of loyalty, the duty of loyalty that exists within the armed forces, right? Because there's a particular role responsibility that they have that other citizens don't have. And perhaps in the draft situation, that becomes very muddy, and I would agree with that, but at least in the volunteer case, I don't see how you can get that off the ground. Good, okay. So, I mean, I think the same principle would apply because in the draft as opposed to the volunteer case, because what you have is the principle of civilian control of the military, and that's something that's obviously very important. I don't think that I think it would be a lot more of a worry if soldiers were going to fight wars that weren't democratically authorized rather than refusing to fight wars that were. And I think that it's an important safeguard in recognition of the fact that democracies do fight unjust wars. And if you think about an analogy with someone who's in a state that has the death penalty and who is the executioner, I would certainly think that if you believe that the person you're going to execute is innocent, then you should definitely, you should certainly recuse yourself at the very least, and you should also try and give whatever evidence you can to try and make sure that person is saved. The idea that you should just think in that instance, well, I need to obey the dictates of a legitimate procedure, even though I know it to have got the wrong result, or I strongly believe it to have got the wrong result. I think that would be the wrong way to reason. And I think that the situation of soldiers can be much the same. I mean, there's usually going to be a lot more doubt, and that's probably why it would be taken advantage of quite rarely. But the fact that there were people who refused to fight in Iraq indicates that obviously there were plenty of people who were thinking about this. Certainly plenty of the soldiers that I've spoken to have expressed doubts about what they were doing. And I think if they had the ability to express those more publicly, then that could make a difference to the government. And I think that, that what we should expect our soldiers to do on our behalf is just the same as what we should expect in terms of their conduct in war. You want them to obey legitimate orders. You don't, if they're ordered to kill a bunch of civilians, then you don't want them to obey that. And similarly, if they're ordered to take part in an aggressive war, then you don't really want them to obey that order either. You might understand why it's more of a trade-off in that case, because if they disobey all those orders, then will we ever be able to fight the justified wars and so on. But certainly giving more provision for selective conscientious refusal would be, I think, a justified starting place.
Are there any further questions? Okay. Well, thanks very much, Seth. Please join me in thanking Seth Lazar for a great paper. Thank you.